I will get started with introducing your panelists and then let them take this away because they're the ones with all of the knowledge. So I'm Dr. Kendra LaRoche. I'm the Executive Director of the Special Needs Support Center, and I know several of you, so welcome here. At SNSC, our mission is simple, but it's powerful, to make the Upper Valley a place where everyone can belong. And that, of course, includes all of you, any of you who have children with disabilities, and I mean children of any age with disabilities. And the goal is for them to belong in their own community. I stepped into the role about 2 years ago, and I've had the joy of walking alongside families like yourselves, advocates, professionals like those on our panel today, who are helping to build a more inclusive future. My background is in education and community leadership, but my passion is really helping families, and to have that problem right in front of you that you say, I don't know what to do next, but you identify the problem and helping you work through that. So that's why we brought these lovely panelists today. So I will introduce them. First is Alisha Cahall, and she is from I feel like I should have asked you how to pronounce some things. I'm sorry. Morneau Law?
Yes.
Okay, wonderful. Powerhouse of knowledge when it comes to trust and estate planning, special needs planning, and elder law. Alisha has a gift for making the complex feel clear and manageable, helping families plan for the future with confidence and compassion. Before moving to New Hampshire, so she's our New Hampshire expert, for those of you from New Hampshire, she served as counsel for the New York City Department of Education Special Education Unit, so she knows firsthand how important it is to protect the rights and needs of individuals with disabilities. You'll quickly see why her clients feel like they're in such good hands. She's warm, practical, and genuinely cares about the families she serves. Next is Kaitlyn Keating, who is from Caffry Keating. She's a dedicated advocate who helps families navigate estate planning and special needs law with expertise and empathy. A Vermont native, right? We have New Hampshire and Vermont. For all of you who are like, how are you going to tell the difference between each state? We have both represented. Kaitlyn has deep roots in our region and a deep commitment to making sure families feel informed and empowered as they plan for the future. Her work is all about providing peace of mind, and she somehow manages to do it with equal parts brilliance and approachability. I'm pretty sure by the end of tonight, you'll wish you could organize your whole life, not just your legal documents. And lastly, but certainly not least, Kate Medeiros, who is on the board, one of the board presidents for the Special Needs Support Center. And in this case, she is from Torch Family Capital. Kate brings a truly unique combination of skills. She's both a certified financial planner and a BCBA, board certified behavior analyst. This means she understands not only the numbers, but also the people and family systems behind them. Her career began working directly with children and adults with disabilities, and today she helps families make financial decisions that reflect both their values and their goals. Kate has a wonderful way of turning financial planning, a topic that can make some of us break into a sweat, into something empowering, hopeful, and even inspiring. So that is our panel. How this is going to work is I'm going to start with, honestly, I have just a few questions. And these questions are going to get them to give you the basics, the structure, and then we're going to open it up for questions from you. But we're hoping to start with that basic structure so that you know if they were going to answer a question already in their presentation that it's going to be done, and then we'll get questions from there. A reminder that this is the first of 3 sessions, and everyone who signed up did sign up for all 3 sessions. And so this one's on guardianship, alternatives, and entitlement programs. And it's really the baseline for the next session. So if you know someone who's like, oh, session number 1 was really good, you should come to number 2, we will send out the video of this. This is being videoed. To anyone who wants to come to session number 2 but missed this one, because we do feel like it's really important that you get this before coming to session number 2. All right, we're going to get started now. I'm going to stop talking. To start, could you explain the key differences between guardianship and its alternatives, such as supported decision-making?
So I can start with that one. So I like to read off of paper if I'm not conversational. Guardianship is a court-supervised legal arrangement where a guardian is appointed to make decisions for an adult or minor who is unable to make their personal, financial, and medical affairs due to incapacity. Powers of the guardians are tailored in each case, and the court has the obligation to choose the least restrictive alternative and can take into consideration whether supported decision-making can supplement a guardianship. Reporting requirements in New Hampshire depends on whether the guardianship is over the person or over the estate, or guardianship can also be over person and estate. And this is in New Hampshire.
And it's really similar in Vermont. Guardianship, as she said, is in the probate court. That is a court-appointed position. You are a legal guardian as appointed by the court. That means many different things. Alternatives include supported decision-making. They include power of attorney and advance directive for healthcare. Raise your hand in the room and maybe at home if you yourself have executed a financial power of attorney document appointing someone to make financial decisions for you if you become incapacitated. And likewise, with an advance directive for healthcare, you can appoint someone to make healthcare decisions for you if you are not able to make healthcare decisions for yourself. If the disabled adult child, for example, is able to execute those documents, that's an example of an alternative to guardianship, because they have the capacity themselves to execute those documents and legally appoint their agents to act on their behalf. But it's when they don't have that capacity, when they're not able to legally sign a document, or if they're just not able to understand the document and understand what they're signing and understand the consequences, that's when you talk about supported decision-making or guardianship.
Right. And so guardianship is more the most restrictive form that can be placed on a person. You're taking away that person's autonomy to make their own decisions. When they don't have that decision-making capacity, then it's usually a probate proceeding. It is considered litigious in the sense that the person who's petitioning the court to be guardian over what we'll call the incapacitated person is the ward. Both parties need to have their own attorneys. And in New Hampshire, there's court-appointed attorneys that would be appointed for the individual with incapacities. And so that's, in a sense, why it's considered litigious, even though most of the time you're really working together to ensure that a guardianship is put in place over someone. But again, it's the most restrictive form that there is because you're taking away someone's autonomy to make their own decisions. Supported decision-making, on the other hand, is a lesser restrictive alternative. In New Hampshire, the statute was implemented in February of 2022, and it works, I would say, in conjunction with those powers of attorney documents that Kaitlyn mentioned. Usually when somebody has some basic form of capacity and they can understand and sign a supported decision-making agreement, we also usually advise clients or their children, if they have the capacity, or the individual, to also execute and sign powers of attorney documents as well. So I do want to say that in New Hampshire, supported decision-making, I've had clients sign supported decision-making agreements. Only a handful of people have. And so in theory, I can explain how it works, but I haven't really seen it out in practice to know whether or not there are any issues with that. I do have clients say, well, what happens if something really major happens and that person, or let me just back up a little bit. So supported decision-making, you usually have a supporter who is a person that the principal of the document is leaning on to make decisions. That supporter can't influence that person to make the decision. What they need to do is help to support the person, that principal, to make their decisions. So if they need help with a financial decision, they're in a bank and they want to know whether or not they should open up a bank account, that supporter could be in the room with them to help them to make that decision. So it's explaining maybe in terms that that person can understand financial matters so that they can decide whether or not they want to open up a bank account. It's explaining to them how the process that they would go about it. But that person, that principal at the end of the day is making that decision. Okay, yes, I do want to open up a bank account based on what my supporter has said. Or if the principal needs to make a medical decision, that supporter can also be in the doctor's room with them and explain things to them in terms that they can understand in order to make a medical determination. So should I take this medication? What will it do for me? What are the side effects? So that supporter can be in the room to help that person make the decision. But at the end of the day, the principal, the person who's signing that agreement, is making the decision at the end of the day. So that's essentially, it's a lesser restrictive alternative in the sense that they still have their autonomy to make that decision, but they have some people to help them. So again, in theory, that's how it should work. I haven't seen it work in practice to know whether or not it works, but I can imagine there are issues with it. It's just when you're in a guardianship proceeding, usually the judge does ask in New Hampshire whether or not supported decision-making was taken into consideration. The judge is taking a look at all the facts and whether or not this person can make their decisions or whether or not they can't. And that's when a guardianship would be imposed.
And an important distinction, I'll distinguish Vermont. Supported decision-making is not terribly new for the world, but it is new for the U.S., and not all states have jumped on board with supported decision-making. Vermont is one of those states, but it's coming. And as Alisha said, it's new enough that we don't know exactly how it's going to work in practice here in the U.S., some issues with it might be, for example, how legally binding is the supported decision-making agreement? A court-appointed legal guardian is the bottom line. You can sign on the bottom line and you have a gold seal from the court backing you up. You don't have that same support with a supported decision-making agreement or a financial power of attorney and advance directive for healthcare. Also, I don't know how you're drafting your supported decision-making agreements, but for the power of attorney and advance directive for healthcare that we all should have for ourselves, you can revoke that at any time. So if your adult child is someone who needs support making decisions because they're not great at making decisions for themselves, is it possible that they would, for lack of a better term, on a whim, decide to revoke their document and revoke your power under any of those documents? If that's a risk, then you may want to be looking at a more binding, controlling, and it is controlling, arrangement, which would be a legal guardianship. And Alisha also mentioned you can't, obviously, but I'll say it anyway, you cannot have undue influence on the person who is signing this supported decision-making agreement. There's a risk of that with supported decision-making because there is not oversight from a judge. That can be a good thing in many situations, that you don't need to involve a court in every action that you take. But that is an extra layer of protection. If you are asking a court to be appointed legal guardian of somebody else, as Alisha said, not only does that other person get appointed their own attorney to represent their expressed interests, whether it's their best interest or not is irrelevant, it's their expressed interests. In Vermont, parents or people seeking guardianship do not need an attorney to represent them. They can do it themselves. But they have to go through the court process. There is a background check that is performed to make sure you are capable of serving as a legal guardian for this person. And there's essentially regular surveillance of what you're doing. You need annual accounting submitted to the court. You're held accountable to the court as a legal guardian, which is cumbersome and it can be obnoxious, but it is that extra layer of protection for the individual under guardianship. And did you have a question?
Yes, I'm wondering who makes the determination whether the person is going to be supported or not supported?
In a guardianship or in the supported decision making? In the guardianship, it's the judge. Should I pause?
Shut that.
Feedback.
Great. I think we're good. Sorry. Okay. They're all off right now. Okay.
Can you all hear me if I'm talking? It's worse because
I'm sorry. Is anyone using the hearing things? If so, could we turn them off? I'm so sorry. I want you to be able to have that. Oh. I'm so sorry. Are you still able to hear okay? Not really. I'm sorry, everyone. Give us a second to try to help this. Because obviously, it's important for people to be able to hear. We turn that on. I think we can turn ours back on.
How is that?
Great.
And can you hear me? Yeah, okay. If everyone can hear me. So I think addressing your question, which was who makes the decision as to whether an individual needs a guardianship or needs support making decisions. In the guardianship world, in the court, that's the probate judge. And in Vermont, actually, if you are under guardianship with the public Office of Public Guardian, you're under the guardianship of the state because there is no family member or friend who is serving as your guardian. You are a ward of the state. That's actually in family court. That's a family judge. It's a little arbitrary and it doesn't quite make sense in Vermont, but that's how it is. Likewise with mental illness. If you are an individual with mental illness and that's the primary foundation of your guardianship, you're headed to family court. But either way, it's a judge, either in family court or in probate court. Most families who are seeking guardianship of their adult child or sibling are going to the probate court, at least in Vermont. And the process is quite a process, but it's ultimately the judge who makes the decision. There is always an independent evaluation performed of every individual who is potentially under guardianship. So a professional psychiatrist, psychologist, professional medical professional is doing an assessment, and they can be quite lengthy with the individual whose guardianship is proposed, and they submit that independent evaluation to the judge, and the judge takes that under consideration in addition to any and all of the other evidence produced by the parents, the family, the individual, him or herself. But the judge ultimately is the one who makes the decision regarding guardianship.
Can I just finish that and then we'll get to your question? So in New Hampshire, there's no separate evaluation. It's usually, and I'm kind of jumping ahead because it kind of hits on the second question too, but in New Hampshire, incapacity is based on a legal disability, not a medical one, and so it's based on functional limitations of the individual. So usually what happens is, does that individual have an inability to take care of themselves in order to provide for food, shelter, healthcare, safety, and all that sort of thing. So it's based on evidence on what the petitioners bring to the table, and usually it is based on the last 6 months and maybe 20 days prior to filing the guardianship, and they can't be hypotheticals. They have to have been instances that prove that this person has an inability to take care of themselves, whether that be activities of daily living, that person needs help with maybe 2 or more ADLs, activities of daily living. They also just don't have the wherewithal to make competent decisions on their own. So Even though we don't have a separate evaluation, it's still based on what the functional limitations are that determine a person's incapacity that makes this person legally incapacitated. And the judge in the probate court, similar to Vermont, makes the decision based off of that evidence that's presented. Medical evaluations can be a part of the evidence as well. It can be still presented during the hearing, but at the end of the day, the court is really looking at those functional limitations. Supported decision-making, on the other hand, that individual is meeting with an attorney. The attorney is assessing their capacity to understand and sign the document. And again, as we mentioned before, if I'm meeting with that person, I will also put on the table that they should probably sign healthcare and financial powers of attorney at the same time, because they have the capacity to understand the supported decision-making agreement. They also would have the capacity to sign those powers of attorney document. So an attorney is assessing that person's capacity to understand and then have them sign those documents when they come into the office.
Mm-hmm. We'll take a couple more questions about guardianship, and then we're going to move on to a different topic. Go ahead.
Is there in Vermont a difference with voluntary versus involuntary guardianship for adults that a parent might be trying? And if it is a voluntary guardianship where the child says, yeah, that's great, do you have to go through as rigorous of a process as what you described? Is question number one. And question number two is there a process if you move from Vermont to New Hampshire or vice versa? Do you have to go through the whole process again?
Great questions. First question was difference in Vermont between voluntary and involuntary guardianship. There are two different kinds of adult guardianships in Vermont probate courts, and that's voluntary versus involuntary. I would venture to guess that supported decision-making will ultimately end up replacing more of the voluntary guardianships, because voluntary guardianship is when the individual, him or herself, says, I need support making decisions, I need help, I need my parents, for example, to be making medical decisions for me and signing legal documents for me because I don't know what they are, but I know that I need help with them. You can petition the probate court to have a guardian appointed for yourself. That's a voluntary guardianship. I do very few of those because if you really think about it, if that person has the ability, the capacity to say, I need help and I'm going to submit this form to the court, then they probably have capacity to sign a power of attorney and an advance directive for healthcare. More often than not, situations that start as petitions for voluntary guardianship are turned into by the judge involuntary guardianships because it becomes apparent through the process that the individual actually does not have the capacity that they thought they had or think that they have to manage their legal, financial, and medical affairs. So that's generally a voluntary guardianship. It's generally the same process. There is still an independent evaluation. Legal guardians still have to have a background check to be appointed. But there's less risk, certainly, of contention because the person seeking guardianship is seeking guardianship, which the guardians probably want. So you're all seeking the same thing. An involuntary guardianship is potentially contentious, not always, but that's more, it can be more difficult for a judge. An involuntary guardianship can be easier for a judge because there are lots of folks where, frankly, it is so clear that this person is not making medical and financial decisions for themselves. That the evidence is abundant. They try to have a conversation with this disabled adult child. It's not happening. There's clearly a lack of understanding. Those cases, again, frankly, are simple for the judge because it's very clear. The challenging cases are where the individual does not, according to the people seeking the guardianship, does not have capacity to make financial decisions, legal decisions, medical decisions for themselves, but they think that they do. And maybe they do. Who am I to say? The state of Vermont will always intervene in those cases because the state of Vermont has taken a stance that individuals can make whatever decisions they want for themselves, even if it's not in their best interest. This is most common in cases of mental illness.
And that's the same in New Hampshire too.
And there are no, in Massachusetts, they're called Rogers orders. There's no authority from the court to allow a guardian to impose medication, for example. So if the individual refuses to take psychiatric medication that everyone over here is saying is in their best interest, the state of Vermont says, and I guess New Hampshire also says, they have a right to refuse that medication. Those kinds of involuntary guardianships can be really challenging because those, in those cases, or many of those cases, the individual has every right to be actively fighting against the guardianship. I do not need to be under guardianship. Here's my evidence why. My parents should not be my guardian. Here's evidence why. And they have as much of an opportunity to fight against the guardianship as the parents do to fight for it. So those are really the major differences between voluntary and involuntary guardianship, at least in Vermont. Again, voluntary guardianship is much less common and probably what will be replaced with this newer supported decision making. Does that answer that first question, voluntary versus involuntary? And you will need to remind me of your second question.
If you move from Vermont to
Thank you.
New Hampshire, vice versa.
Yeah. Vermont, New Hampshire both follow this uniform code, basically, that allows pretty much simple transfer. It's typically a 4-step process. You have to petition the home state to release the guardianship, bring that to the new state and say, look, Vermont's ready to release the guardianship. Can you preliminarily accept it? You bring that acceptance back to Vermont, who releases it, and then you take that final release to the new state. That's typically 4-step process. I'm oversimplifying it, but that's generally what it is.
Yeah. That's a good simplification. And it's not just New Hampshire and Vermont, because it's from any state, just because of that uniform Guardianship Act.
Yes.
We're going to take one more question, and then we're going to move to a different topic, but we will come back if there is time. We want to make sure we get to all of the topics, but we will come back if there is time. Is there someone online who wants to speak? Yes, why don't you let them go next?
Go ahead, Helen, if you can unmute.
Yeah, I'd really appreciate it if, when you get a question, if it could be repeated, because we can't hear the questions.
No problem.
Thank you.
I'm terrible. I remember to do that. I've got to remember.
Did they have a question?
Nope, they just want us to.
They just want, okay,
Repeat.
great. Yes, go ahead.
So we are the adoptive parents of twin 19-year-olds who have intellectual disabilities on top of mental illness. We chose not to pursue guardianship prior to their 18th birthday, and we're absolutely regretting it now. It would have been a lot easier, I know, if we had done it with the help of the state. We really wanted them to be able to have that autonomy. I guess the question that I have is, I'm hearing that they have to fail in order for them to get help, and we're scared. They're going to be with us for a long time.
Great. I'm gonna repeat that question a little bit, and thank you, just so that the people online can hear.
We just need to know if there's guidance to help us at this point.
And what state are you in?
Vermont.
So there's kind of two parts to this question, I think. The broader part for everybody is, what factors should you consider, and at what time should you consider those factors in determining guardianship? And if you do wait longer, which I can see why people would wait longer, right? Like, let's give them a try. What are some of the pitfalls that could happen at that point, and then what do you do?
Yeah, and your concern is really valid too, because you're not wrong. In most of the benefits programs that we'll talk about later and in other sessions, the comment was made that in many of these situations, we need to see the adult individual fail in order for them to get the help that they need. That's the horrific reality that many of you are facing all the time. In terms of guardianship, and just in the lane of guardianship, I would ease your mind. You're never too late. You can apply for guardianship at any time as an adult. Is it easier to have the conversation with an adult child turning 18, just saying, this is something you have to do now that you're turning 18, and make it part of the transition to adulthood? Sure, maybe that conversation is easier, but you can petition for guardianship at any time once your child is an adult. If you have a 17-year-old or 16-year-old, you should be thinking about guardianship now, because in Vermont and maybe New Hampshire, you can apply up to 4 months prior to their 18th birthday, with the intent being you ensure that guardianship is in place by their 18th birthday. Does that always happen? No, the courts are slow and getting slower. So are the attorneys. So does that always happen in 4 months? No. I was working with someone recently who they were petitioning for guardianship for their daughter. It was not in place by her 18th birthday. She had a medical crisis after turning 18, but before the guardianship was in place. There are temporary emergency guardianships that you can use in those situations. That is similarly submitting a petition to the probate court to say, I need guardianship, but you're saying, I need it now, I need it today without an evaluation, because this is the harm that will result if I don't have it today. And so that's how parents or families can help their adult child when there's a crisis and there's not a guardianship. But there is time after age 18, any time after age 18, that you can be applying for legal guardianship.
It was also whether we should be that person. So we're in our mid-50s. I mean, obviously we've still got lots of time, or at least I hope, knock on wood. And we have an 8-year-old on top of that. So, but as we look towards the future, when we're not there, how do we make sure that somebody is? Is there a guardianship? I heard you talk about the state, and in my mind, like, it's contentious right now. Like, it's a battle with these two boys. And so how can we do it right now and start planning for them, for their future when we're not here?
So the question was, how do you plan for the future when you'll likely outlive your children or perhaps other family members? And how do you replace that guardian, or should the parent even be the guardian? I believe that covers your question. And that's really case specific for obvious reasons. If you are paid to care for a child, you cannot also be the legal guardian in Vermont. So that's a consideration. More of a consideration for siblings, for example, because a sibling can be paid as a shared living provider and live with their disabled adult sibling, but not if they're the legal guardian.
So that's a distinction. We don't have that distinction in New Hampshire. You can be a paid caregiver and still be the guardian as well. We just have to have really good documentation and contracts in place.
That's something, that's something to consider when you're evaluating whether should I be the guardian. If you're in Vermont, that's a real consideration.
Right. And we want to build a home on our land for both of ourselves to live in, so that could very well become our situation.
So being appointed as guardian today also does not mean you have to be guardian for this person's entire life. You can transfer guardianship at any time. That replacement will have to go through the same background check that you did. If you are getting on in age or activities and you just don't have time or capacity to be serving as guardian for your child or for this individual anymore, you can have someone else petition to replace you in the court as legal guardian. Your wills, your last will and testament, is also your opportunity to identify your nomination to the court, who you want to serve as your replacement legal guardian after you die. You absolutely should make sure that's spelled out in your estate planning documents.
Do you use letters of intent?
Yep.
Okay.
Yep, letters of intent similarly.
Okay.
Letters of intent are not legally binding, but it gives a guide to the people you're leaving behind. Mm-hmm. This is my intention for my child or my family member. And also remember that legal guardian does not mean custodial guardian. So someone can be a legal guardian. Again, it's their signature on the bottom line, but they could live in someone else's house. Absolutely. They could live somewhere else you don't have to be the legal guardian and custodial guardian.
All right. So you started to get into entitlement a little bit because you were talking about in Vermont how you want to consider the financial piece of caring for someone in addition to the guardianship. So let's move in that direction. So many families are unfamiliar with entitlement programs. Could you just walk us through SSI, Medicaid, Medicare, and what they cover for individuals with disabilities?
So I'll give a little primer on all that, and you have some handouts in front of you. I'm going to start with the comparison chart on Social Security programs. There, no, the other one.
Nope,
Yep.
the other one.
That's Medicaid. Right, the 3 Social Security programs. So Social Security retirement is tied solely to work history and age. So once you reach a certain age, then you start receiving Social Security retirement. Social Security disability insurance, on the other hand, or what I'm going to call SSDI, is tied to work history and the existence of a proven disability. And supplemental security income, or SSI, is also tied to a person's disability, but the eligible individual also lacks a sufficient work history to tap into, and SSI has strict financial eligibility rules. So you have Social Security retirement, then you have Social Security disability insurance, which is SSDI, and then we have supplemental security income, which is SSI. So,
Can I interject real quick?
Yeah.
Because we're using the word entitlement, at least in our office, we make a distinction that Social Security retirement insurance, Social Security disability insurance, SSDI, those are entitlement benefits because you worked, you paid into the Social Security system, and you are entitled to those benefits. But SSI is not an entitlement benefit. You have to qualify.
and that's a good distinction. Thanks, Caitlin. So to be eligible for SSDI, that's that Social Security Disability Insurance, an individual must be blind or disabled under the Social Security Act. Disabled means incapable of engaging in substantial gainful activity due to a cognitive or physical impairment expected to last 12 months or result in death. And in 2025, that substantial gainful activity is earning $1,620 or more per month. So if that individual is earning more than that, then essentially they're not determined to be disabled. Someone seeking SSDI must have a requisite work history to tap into, meaning the individual personally worked a sufficient number of quarters to become insured or is tapping into someone else's work history. Notably, a child can tap into a parent's work history if a child's disability arose before age 22 and the parent is retired, deceased, or disabled. Supplemental security income, which is SSI, works very differently from SSDI and typically offers a far more modest monthly check to an individual in need. SSI is a type of cash assistance for folks with an insufficient work history. The individual must similarly be blind or disabled, but because the benefit is not tied to work history, there are financial eligibility rules. And the government looks at a person's earned and unearned income available to pay for shelter. So if you have your pens at the ready, I do have a little typo in that chart. And if you go three, what are these? Not the columns, but the other rows. There we go. If you go 3 rows up from the bottom, I have that in-kind support in the form of food and shelter is counted as income up to set limits. I want you to remove food. It's only shelter. So food was removed in September of 2024. And I'm so sorry, I just didn't update my document to remove food. So in-kind support is just shelter. That does not take food into consideration anymore.
For all 3?
Yep, for all 3. Correct, across the board in that row. So SSI gives a person with disabilities a very modest subsistence check. And in 2025, the monthly check for a single person is a maximum of $967 per month.
And Vermont has an extra benefit of typically around $55. That's the aid to the aged, blind, and disabled, AABD. It's an extra benefit for SSI recipients.
And now we're going to switch over to the comparison of Medicaid and Medicare chart. So that's the second one.
So what you said about how they removed the food from that, does that mean then that SSI is exclusive to pay for shelter?
Correct.
That's it?
Correct. Yes. I know they had clothing in there at some point in time too that was removed a while back, and just good people just advocating to remove food as well. And I know 967 is not that much. I get that a lot from my clients. That can't pay for a one-bedroom apartment in New Hampshire. How are they supposed to live? And we'll get to that. We'll probably touch on that in the next session as well too. So, all right. So on the comparison of Medicaid and Medicare chart, so in addition to needing help to pay for basic monthly living expenses, someone with special needs also might need help covering medical care or prescriptions, home care assistance, or nursing home care in a facility or a home, or even case management. Medicare is a federal program offering medical insurance to someone who is over 65 or who is younger and disabled. But Medicare is tied to work history. Sometimes it's the history of the person with disabilities, or it's the work history of a parent if the child became disabled before the age of 22.
And if I may, similar to the conversation about SSDI being an entitlement benefit and SSI being means tested, income and resource tested, Medicare goes with SSDI and is an entitlement benefit. Medicaid is resource tested like SSI.
So
income and resource tested.
Right, financial eligibility requirements. So many, I didn't mean to cut you.
Yeah, no, I cut you off.
Many Medicaid programs require disability in order to become eligible. These programs offer a broad range of critical supports and services for children and adults with disabilities. And like the federal SSI cash assistance benefit, Medicaid programs also are based on financial need. Some programs have both income and resource eligibility rules, while others are based on an individual's or a household's modified adjusted gross income, which is what we call MAGI. So that's just a little primer on the little differences between SSI, SSDI, and Social Security retirement, and Medicaid and Medicare.
I'll add to the conversation about a disabled adult child being able to tap into mom or dad's Social Security benefit. Again, that happens upon the parent's disability, retirement, and or death. But be aware that that income, let's say your Social Security check is really solid and it's pretty big, which means when your child starts receiving their SSDI benefit as a derivative of your benefit, that's called CDB, Childhood Disability Benefit, not to be confused with CBD, CDB, Childhood Disability Benefit. That is the benefit that the disabled adult child gets when they are disabled before the age of 22 and receiving that SSDI from mom or dad's work record. It's 50% of mom or dad's, the higher wage earners, Social Security amount until mom or dad die, and then it bumps up to 75% of mom or dad's Social Security amount. So if you have a hefty Social Security check, good for you. And that means that your child's income, when it becomes 75% of that, might exceed the income limit for Medicaid. If you had SSI, supplemental security income, at any time, in any amount, for any time, Medicaid will disregard that income, and your Medicaid will continue even though your childhood disability benefit is higher than your income limit. Yep. So if you received $1 of SSI, supplemental security income, in your life, and then your parent dies and you're now receiving 75% of their Social Security amount, and that income is higher than your Medicaid income limit, Medicaid will disregard that income and continue regardless of you being over your income limit.
I have a question.
I have a follow-up, but go ahead with your question.
Okay. We just went through that process with Social Security, and my Social Security benefit is ballpark $500 a month, and our daughter got $14 a month as a result of my $500. That's not 3/4, not anything like that. How did it get to be so small?
So the question is, the parent's Social Security amount is around $500 a month. The child received $14 a month, and they're wondering how that was possible. I don't have the answer.
I don't have the answer to that either. I would think that
sounds wrong.
Yes. Yeah, I would reach out to the Social Security office again and ask them to reassess that, recalculate that.
It's supposed
And
to
is that, this is her SSDI, correct?
She has it comes in with her SSDI, yes.
So the $14 is not her SSDI?
She had her own SSDI to begin with.
Okay.
And that was ballpark, I guess it was up to about 500. And now she's getting 14 more because of mine. So maybe it counts 514.
Yeah, they count. They're going to count
75%.
just like with spouses. Your spouse gets half of yours. They're only going to give her the amount that equals what she should get if she didn't have her own SSDI.
She had her own before,
Yeah.
so that's the reason.
There we go.
Okay,
Yeah.
thank you.
Thank you.
Did you want to finish your follow-up and then
If
ask
that's
the
okay, I'll just add my follow-up, and I'm going to look right at these parents over here with 19-year-olds because that's like a precarious age, right? When your child turns 18. And I'm also going back to the later comment I'm pointing here, which is also the camera, but there are parents behind the camera here. The question of how far do you go, or how badly do you let your child fail before you start seeking benefits? And once again, in the disability world, my advice is always going to be push for the maximum, always. Because they could always work their way off of something, but if you miss out, there are consequences. So this is how I'm tying it into this CDB, childhood disability benefit. If you do not apply for SSI when your child is otherwise eligible for it and they're turning 18, because you think, we don't need that public benefit, or we have enough private resources, or we want to see how they do on their own, okay? And then you die, or you retire, or you become disabled. Or in cases where a child's parent died before they turned 18, or became disabled before they turned 18. That means immediately upon their 18th birthday, they're eligible for that CDB benefit, right? And likewise, if you wait because you want to see how your kid does before you apply for SSI, and then you never get around to applying for SSI, if a disabled adult goes on CDB, that childhood disability benefit, having never received $1 of SSI, they lose the Medicaid disregard for the income. And so they could lose their Medicaid in the future. So that's one reason to make sure that you are assessing whether SSI is appropriate for your family member. And if it is, make sure you're applying for it. And you can always forego it later. It can switch to a different benefit if your Social Security amount is high enough and can supplement or replace that SSI. But that's my recommendation. Usually, make sure you apply because you're setting your child up in the future for that Medicaid disregard.
I told you. All right, you had a question, right?
Yeah. I'm an incumbent worker, and
My Social Security was reduced by 50% or more because I was under that windfall elimination thing, which they just recently changed. So my Social Security has bumped back up because I worked in the private sector for 40 plus. Do I have to do this myself? Does the Social Security look at that and say, oh, you're eligible now? Or how does that?
I would definitely call them. Yeah. I think that maybe they will eventually, but if you think that there's a change in your benefit, it's best to be proactive. Yeah, I would. Yeah. Yeah.
Also, a lot of people will go from receiving SSI as a disabled adult, that supplemental security income, and then a parent becomes eligible for their retirement amount. So their SSI is being supplemented or replaced by the CDB benefit. And often those individuals will get their termination letter before they get, a week later, the letter saying, here's your new benefit. And so we have a lot of folks calling the office saying, oh my gosh, what do I do? Why did I just lose my SSI? And in some cases we get to say, just wait a week. You didn't actually lose your benefit. It's being replaced and your income is now more every month. But that's an unfortunate thing that folks are dealing with all the time with Social Security. And it's not getting any easier as they're making changes and reducing staff.
I want to see if anyone online has a question, just to make sure we don't ignore you.
You can just press the button to raise your hand if you'd like to ask a question.
And as a reminder, the next one goes into even more depth on these programs, because this is very confusing, right? There's so many acronyms that these guys are saying that I'm definitely confused, and I consider myself a pretty knowledgeable person, and I'm a little bit lost. So I definitely think that if you're feeling confused, this is like a good primer, and that next time you'll get it a little more because it sunk in a little bit. One more question about entitlement programs, and then we're going to go to Section 8 housing. Yes.
For kids who are under 18, remind me, does SSI have income limits as well? So can you, like, if you apply for SSI to a disabled child,
age 18, right?
And that's, so you should apply even if you would typically have it would have an income limit problem. Okay.
So the first question is whether someone under 18 can apply for SSI, and the answer is no. You have to be 18 to apply for SSI. So unlike the guardianship where you're applying a few months ahead of time, you got to wait till 18th birthday to apply for SSI.
And then just to tie that in with that shelter that we were talking about before. So if that individual is living with somebody and that parent, for example, is providing them with in-kind support in the form of shelter, that $967 per month cash assistance in SSI, which is that maximum amount, would be reduced by about a third. So if you have an individual who is on SSI and they're only receiving 600 something plus, it's usually reduced by that 1/3, because if you're the parent, you're providing them with shelter.
And in Vermont, submit a room and board agreement as a parent and show that you are charging your child rent as much as that makes your stomach turn. It is over $4,000 extra per year that your child will take in from SSI if you simply submit a room and board agreement showing that your child is paying you rent. And then they use their SSI check to pay you rent, the amount you've decided on. You can do whatever you want with it, that's your money, but you could put it in a separate account of your own that you only use for that child.
Right.
But make sure you charge your child rent, because you'll maximize their SSI benefit if you do.
$967 a month. If you are the guardian, though, in New Hampshire, you do have to petition the court to charge room and board. Yeah.
Can I just ask, I feel really silly asking this question. So who determines whether your child is disabled or not. So I'm told that an intellectual disability doesn't necessarily mean that they're going to qualify as disabled, although our children have qualified for supports through Upper Valley Services, and one of the twins is in his 5th year of high school, doing Project Search. So all of those things are, how do we know? I haven't applied for SSI because I don't know if they'll even qualify. Do I just do it? Are they the ones who say, yes, this child is disabled? So am I doing exactly what you're saying? I'm not doing any of these things because I'm afraid they won't qualify.
The worst they can say is no.
The worst they can say is no.
Yeah. Question for the folks at home is how do you know when to apply for SSI and other benefits programs, and how do you make the assessment yourself? Does my child even need this? Yeah, let the government program make that assessment. Right. Submit the application and they'll tell you why it's rejected if it's rejected. Oftentimes it's rejected for a wrong reason that you can fight. But sometimes it's rejected because they are earning enough money on their own so their disability is not causing them to be legally disabled. So apply for the benefit and let the government make the disability assessment.
Mm-hmm. Yep.
I have the same question, and you're not silly. When you were saying in terms of guardianship versus support decision making, for the incapacitated individual, who decides what constitutes incapacitated in both of those situations? Because I have a kid who's pretty good comparatively, but he totally melts down when you ask him to make a decision, especially a medical decision. And so it's a completely good question.
Great. They can make the money, but they're never going to live by themselves right now.
Right. So in a guardian,
repeat the question first, please.
Could you? Not good at summarizing. Would you be able to do that?
I'm going to try. So the question was, if, gosh.
What is the question?
Qualifies them as being
incapacitated? Who qualifies the disabled adult child as incapacitated for purposes of guardianship or supported decision making?
Right. So in New Hampshire, guardianship, again, is determined by a legal incapacity, not a medical one. And that is determined by the functional limitations of that individual. So that's the evidence that we're bringing to the court. What are the examples that this person is unable to provide for their food, shelter, healthcare, and safety? And again, that should be examples of the legal incapacity, those functional limitations that are presented to the court in the petition. Should be within 6 months of the filing, and instances 20 days also prior to the filing. And they're not hypothetical. So it's not, if my child were left home alone, he might do this. It's, I need to lock the doors because he's a flight risk. I have security cameras in the house because he needs 24/7 supervision. It's all of those examples that show that he cannot or she cannot provide for his healthcare, safety, make those medical decisions. Give examples. When we go to the doctor, who's the doctor mostly talking to? If they were directing their questions to that individual, what would their response be? Could they provide a response? So essentially, again, the incapacity is a legal one, not a medical one. So you can't just bring to the court that this person has an intellectual disability or is autistic. They need evidence of incapacity. And then the court, the judge, the probate court judge determines based on the evidence that's presented in the petition and also at the hearing, and then they make their determination of whether or not the guardianship is necessary.
May I heard a bit of another question there too. Can it ever be determined that they need guardianship in one area but not in another area?
Yep. So in New Hampshire, guardianship can be over person and the estate, or person or the estate. So if somebody can make their medical decisions fine, but they're not very good financially, so they've had events of being scammed in the past, for example, is one that comes up a lot for myself, then in those instances, you might want to petition the court for guardianship over their estate. If the person can't make medical or financial decisions, then you're petitioning the court for guardianship over the person and estate. The person can, and this also ties into powers of attorney as well. I've had instances where a person has a healthcare power of attorney, but they don't have a financial power of attorney. So now we're seeking petition over the estate, or they don't have the healthcare power of attorney, but they have a financial power of attorney. I think I kind of got those mixed up. So if they have an agent that is making medical decisions for them, there's no need for a petition over the person if that agent wants to continue to make the medical decisions. And likewise, if they have an agent for finances but not for healthcare, and you're petitioning for guardianship over the person, does that agent under the financial power of attorney want to continue? If those individuals don't want to continue, then again, you'd probably be seeking guardianship over person and estate and providing those examples of legal incapacity, functional limitations. And so, again, the judge is the one that will decide based on the evidence. With supported decision making, the person who is determining whether or not there's an incapacity, I would say it's, and you can correct me if you don't think that this is correct, but for myself, if I'm meeting with that person who wants to sign the healthcare power of attorneys and the supported decision making, I'm essentially making that decision if that person has capacity to understand the documents that I'm explaining to them and trying to get their input on who they want to name as supporters and how the supporters would help them in that instance. I'm making that determination. If I don't feel comfortable that this person can understand the documents that are in front of them, then I'm going to respectfully bow out. There might be other attorneys out there who they meet with at another time that might determine that they have capacity, but I would say for myself, I'm making that determination if that person who's in front of me has the capacity to execute and understand that document that they're signing.
Thank you.
I think we have a question from online.
Go ahead, Emily.
Hi, this question is from the topic around SSI reductions for what's considered family support. I have an ADU, which is like an in-law apartment, and I let my son was living in there trying to help support him develop a little bit more independence. SSI said that qualified as some kind of support, and they reduced his monthly allocation, thereby, I'm just wondering, can you explain that wrinkle a little bit?
Yeah, sure. So it's Emily, and did everybody hear the question? Okay. So Emily, you're saying that your son is living in kind of like an in-law apartment?
That's right.
Accessory dwelling unit.
Okay. And then do you have some sort of room and board agreement in place?
Yes.
And you presented that to the Social Security office and they still reduced his check?
That's right. They claimed that 30%, that if he was renting from a family member, then there was some necessary reduction in the amount of his paid rent that would qualify, saying that they assessed a market value for the apartment and then asked me what I was charging him and decided there was some big gift going on. And
okay.
Other states do that. Vermont does not do that. Are you in Vermont?
No, I'm in New Hampshire.
Okay.
Yeah. So what is the fair market value for that apartment?
It's over $1,000, right?
Okay.
I mean,
And
it's more than the SSI value. So
right.
like, what was I don't know what to say, right?
Yeah, and it's so because it's above the 967 maximum monthly check. Let's say if the maximum was $960, just to make the math easier, and the fair market value for the apartment is $1,000. So essentially, you're providing in-kind support and maintenance for $40. That's still a reduction because you're providing an extra $40. Essentially, you're paying for that extra $40. So if there's any way that you could try to reduce does he live with anybody in that apartment? Is he by himself in that apartment?
Yeah, he was by himself. He's not currently living there, but I do think he may want to move back at some point, and I want to try to get ahead of this wrinkle.
Yeah, and usually if somebody's living, I would say 2 people in that unit, then it would be a proportional share of cost, so it would actually cut that in half, and he would get the maximum $967, but it's because he's living there alone, and there's some support that you're essentially paying for the $1,000 from the SSI check, which is $967. So the difference is kind of like he's being given that, and it doesn't really matter the amount. So again, that's like $30-something. The check is still going to be reduced by what they call a presumed maximum value, which is 1/3, and so that's like minus $300 plus from that $967, and that's the reason why it's still being reduced.
Okay, it has nothing to do with the fact that it's rent from a family member or a guardian?
Well, it is, but essentially you're still supplementing that $30 plus per month.
Okay.
Because you mentioned that you have a room and board agreement, and essentially what that $967, the maximum, would pay for is shelter. So that would come into your pocket to pay rent. But if he was living elsewhere, it would still be a 30 plus balance that would still be owed. And it doesn't matter if he's living with a family member or not, because the rent is higher than his supplemental security income. It's still considered in-kind support and maintenance for that little bit of a balance that's due and owing towards shelter.
Okay. Okay, thank you.
You're welcome.
Was there one more, Kate, online? One more from online, and then we're going to really move into housing, as if we're not already there.
Go ahead, Kimberly, if you can unmute yourself.
Yes, my question is, with a young adult child who is not getting Social Security, who has not applied yet, if that person graduated from high school, is working, say, 20 to 25 hours a week, making $1,000, say, does that mean that they wouldn't qualify for any Social Security because they're making more than the $967? And even though they're making less than the $1,620 for SSDI because the parents are working and the parents are not disabled or deceased, then they don't qualify for either, or? That's my question.
Focus on the did everyone hear this question? This young adult person is working a little bit but earning only about $1,000 a month. Is that going to be disqualifying for benefits or for legal disability status? For legal disability status, no. The requirement is if they cannot earn more than $1,620 a month because of their disability or because of their, for lack of a better word, because of their disability, then they are going to be considered legally disabled. There are other income limits for the other benefits, and frankly, it depends on where you live. Even in Vermont, there's different numbers for inside Chittenden County and outside Chittenden County. So it really does kind of depend, but certainly if this individual you're talking about is only capable of earning $1,000 a month, it is very likely that they will be qualifying for some benefits, and some folks need to make the decision also for folks who are very capable but not capable enough to maybe back off on those work hours in order to qualify. And I'm saying that with sensitivity to what these benefits are for, but the challenge for many parents is your child, you push them to be as independent as possible and earn as much as possible, and that lasted a year or 2 years, and they failed. Just don't let too much time go by before you maximize the benefits and then try to work toward independence. That's my very general recommendation.
Okay, but with SSDI, I thought you mentioned that the child could only qualify if the parent is deceased, retired, or disabled themselves.
That's the CDB, the Childhood Disability Benefit, which is under SSDI. You are correct that the disabled adult child who has never paid into the Social Security system herself does need to rely on mom or dad's Social Security benefit to receive childhood disability benefit, which means mom or dad has to be disabled, retired, or dead. But an individual, him or herself, might be able to work just enough for just enough time to earn their own Social Security check, and then they become legally disabled and they're receiving SSDI based on their own work record, irrespective of mom and dad's retirement or disability status. Does that answer your question?
Sort of.
Feel free to follow up.
It's confusing.
Yeah, it is confusing.
It's confusing.
All right, we're going to move on to Section 8 housing. So Section 8 housing is in flux, and actually there's a lot that feels like it's in flux right now, and I'd love to hear a little bit from you about what is actually in flux right now and what advice do you have for families in trying to navigate benefits that might change over time.
So it's definitely hard to answer this question because these rules are always in flux. If someone comes to me with a question on Section 8, I'm usually, depending on the question too, I'm usually saying that I have to do research on that because the rules will be the rules today, but they might not be the rules next week. So it's really difficult to answer this question. It's just too many moving pieces. Different states as well, or different organizations as well within a state can say they're implementing these rules next year, and then that changes. It's just a difficult question to answer.
Could we start with what is Section 8 housing?
Yeah.
How's that one? Okay, great, a little easier.
There still are different levels of housing assistance that's provided, but Section 8 housing is a type of housing assistance that has historically been income-based. You need to have low income to qualify for Section 8 housing.
Right.
You're generally on a waiting list. There are public housing authorities that manage the housing unit, essentially landlords or managing the landlords. And in Vermont, they have a lot of discretion with how they're implementing some of these rules. It might behoove you to Google HOTMA, HOTMA, and start reading about the new HOTMA rules yourself. That's what's in flux.
Right.
There is the HOTMA rules are turning public housing rules on their head completely, but the rules themselves that are proposed right now are so confusing that the experts don't know how to interpret them or enforce them. They were going to be enforced January 1 this year. They extended it to July 1 this year. Now it's extended to sometime in 2026, maybe. Nobody knows what to do with them, so I'm sorry. We won't know what to tell you, and that's frankly what we're telling our clients, is that advice I give you today might not be good advice next week, but let's focus on what your specific housing authority, what rules your housing authority is using today, and let's work within those rules.
Right.
I said historically Section 8 was income-based because these new rules propose a $100,000 resource limit. So for a lot of families that worked really hard to earn $100,000 or more in resources and have been living in Section 8 with no problem, they're all of a sudden going to be facing a problem and maybe eviction. Who knows? There's a lot of scary concerns with housing and very little answers, including from folks like us.
Whose resource is the 100,000? The parents or the disabled person?
Typically, just the disabled individual. Yeah, that's the individual applying for Section 8 housing.
So going back to the person that called in about their child living in their ADU, could I set up an ADU and create it so it's Section 8 housing so that my child could live there, and then the fair market value of the Section 8 would be lower? I mean, am I really being off the wall?
That's a great question. The question is whether someone could establish an accessory dwelling unit on their property and operate it as a Section 8 housing unit.
So that the individual, the child who needs housing.
Yeah.
Could be renting that, but the fair
So that
market
the
value
child
would be less,
renting
right? I mean, then. so
could
if
rent,
she was
but the
calling
fair
about
market value could be
$1,000,
less.
That would be too much, but I don't know if that's even been explored.
That is a good question. I think for Section 8, though, I mean, it has to qualify. So if it's just one ADU, I'm not sure if that's going to qualify for Section 8.
Section 8.
Right. There's still housing requirements that you need to qualify in order to fall under Section 8.
So I did check into it because we have 9 acres of land and we have 2 house sites. And so we wanted to put something down there for our sons. And when I explored, could we do an ADU? Because I was looking for grants. What they ultimately told me is that if I established that, I'd have to open it up to anyone.
Right.
So there's no guarantee that my child could move into my ADU because it just, so they said, don't do that, because that could create a huge mess.
Yeah.
And so we're ultimately going to have to just build one on our own and put them in it and not open it up. There's so many of these barriers, of this red tape you've got to cut through. It's so infuriating.
Yes. Yep, you're not the only person to say that. It is frustrating.
On housing. We live in rural, up near Bradford. There's nothing for kids. And so this would be a solution. But they've got to make it virtually impossible to have that solution.
Right, back here.
So just in general, for people who are, disabled people who are living in supportive housing, like people who homes in the area, who was paying for that? Like, how was that getting paid for?
That totally depends, and that'll be the 3rd session, I believe, of the program, all about housing. Because Section 8 is obviously government supplemented housing, but some of the group housing or independent living situations is someone's Medicaid budget funding housing. That's a very, very good question. Who is paying for someone's housing? And that is kind of the crux of the conversation in the 3rd session. It's so nuanced, and the answer is it depends. So I'll defer to the 3rd session for that.
And I will say that 3rd session is a little bit different. You'll see these same faces for session 2. Session 3 will be totally different with a different lawyer, and then the heads, this kind of CEOs of a couple of different options of those group homes, one in Vermont and one in New Hampshire, who are going to be here. So it's a little bit of a different piece, but we'll hold that question for that 3rd session. Yes.
Certain parts of it are allowed for people with disabilities and other types of persons.
The question is whether Section 8 housing units set aside units for people with disabilities versus people without disabilities. I don't know the answer to that. And again, it's the specific housing authorities have discretion. I don't know how much discretion they have in that regard. A comment earlier too about trying to set up an accessory dwelling unit as Section 8 housing on your property. I've worked with clients who were renting from their dad as Section 8 housing, but I didn't help them do it. I don't know how they got there. But once again,
I know the answer to this one. So at least I know in Vermont that because Section 8 housing, so much of that housing is required to be accessible by law because there's some funds that are requiring that accessibility. But those accessible dwellings are not required to be held for people who need the accessibility. And so accessibility in housing is a huge issue right now in the Upper Valley. And it's not held in Vermont. I am unsure of New Hampshire. Any questions from online folks about Section 8 housing?
Because we've been so helpful so far.
Yeah. Go ahead.
Section 8, they look at household income, correct? So it's not individual. So if the person you can't be on a waiting list if you're still part of someone else's household, correct? Like how do you get out of the household in order to apply for Section 8 as an individual?
The question is, how do you, if you're applying for Section 8 as an individual, but you're currently living in a household, and Section 8 looks at household income, how do they make an assessment of your individual income?
For a disabled person.
I mean, I don't have the answer to the question, but I think just thinking through it logically, if that disabled person is the one that's moving into the Section 8 housing and it's just that person, I would say that would be a household of one. I can't guarantee that that's the answer. I'm just trying to think through it logically. Even though they're still living with other individuals, if they're the one that's applying to live in Section 8, I would think that it's that person as one and a household of one for them.
Yeah, I did that. My daughter lived with me, and we applied for Section 8. And she is able to provide herself applying since her income.
All right.
Yeah, there's a comment from the crowd reiterating what Alisha just said, that that's, if you're applying as an individual, you need to divorce yourself from your parents or your living situation for the purpose of the application.
Thank you to the person in the back.
So I'm going to follow up on that question. Sorry, this isn't one of the ones on here, but the question was really about how do families navigate benefits when they might be in flux? Are there other benefits that are currently in flux, and what is your advice for families about navigating those? Move away from Section 8.
Yeah, I would say Medicaid is one that I get a lot of questions on. There's like that, the rules on Medicaid and everything that's happening in the news today, it's kind of, I would say, up in the air for people, but I would say that the rules right now are the rules right now. And I can at least give you advice on what I know right now. So, Medicaid, I would say, is one piece of it, but.
It's a very hard question to answer because really, who knows? Even Social Security, we're talking about Social Security being an entitlement benefit, that you are entitled to that benefit because you paid in to the Social Security system. But we also know there's discussion around the country that maybe that won't exist at some point. So if you paid into the system, maybe you won't get anything. I don't know if that's a reality, but that's part of the discussion. And so I can't advise on that. I can only advise on what the rules are today. And unfortunately, it is also case by case for some people. But
we get a lot of those questions in our office too, specifically around Social Security. And I think the best thing that you can do is just, as best you can, make sure there's other game plans. And that sounds so daunting because there's so much red tape and there's so much to learn and to do. Find a person, if you can, that can walk through 75 scenarios with you and make sure that as best as your resources allow, you're coming up with plans that if something happens, you have a step two.
That is where the estate and special needs plan are essential for families like this.
Yeah. Yes, I'm back.
My family member has been benefiting from Medicaid for many years now. However, I'm being told that he is not qualifying for ABT cash or food stamps because I don't have guardianship with him. They have denied him that for the last several years. And I don't know if that's legal. Is that legal for them to do that? To say that he cannot collect, he cannot have food stamps, and he cannot
this
get ABT cash?
Person is asking, the disabled adult individual is being denied food benefits and other public benefits, and the reason given is because they are not under legal guardianship. Is that the question?
So my follow-up question to you is he under guardianship? Is there anybody else that's under that is the guardian for that person? And then my next question is he the one that's applying? Has he filled out the applications? And then they're denying him because he doesn't have a guardianship. Okay.
I'm finding when I have my brother, he's 70 years old. He had a TBI when he was 18 months old, and he had cancer in 2015 through so it's a long story, but I was basically, I had medical guardianship on him when he lived in Caffry Keating. But because of the issues with how he was cared for, he wanted to come up and be near family. agreed to have him come up and live with me. The state required me to put guardianship in place in Vermont before I find out, which can't happen. He has to physically be living in Vermont to go ahead and apply for guardianship. So I did everything they wanted me to do, and it was a long report that went on for several others. Anyway, so then they denied him Medicaid. And I'm being told that it's because I have guardianship, they consider my household income. That was Hitchcock Hospital, is what they just told.
So I would say for the two of you,
Can you repeat hers a little bit?
Yeah, go ahead.
Or I'll repeat it, but just another individual talking about being told by the state you need guardianship for X, and then obtaining guardianship and saying that the guardianship is preventing them from getting Y. Does that make sense? Okay. Go ahead, sorry.
So I would say for the both of you, I would need to flush out a little bit more information in order to answer your questions. There might be just digging deeper into what the issues are, and then just talking to you about that and potentially what the next steps would be there. It seems like a lot to unpack. There's just some more information that I think is just out there that I'd want to try to get from both of you in order to start putting pieces together. I hear what you're saying, but I just think that there's some additional information that I would need in order to answer those questions appropriately.
And I have the same thought and response. Mm-hmm. Very generally speaking, when you are a legal guardian for someone, your finances are not their finances and vice versa. It is totally separate. You might be a parent or a sibling. That's one hat that you wear, but it's a totally different hat to be a legal guardian, and their financial liabilities are not your personal liabilities. So very generally speaking, your income and resources are not counted along with the individuals just because you are their guardian. But very similarly, I would have a lot of follow-up questions for both of you before I bothered to make an assessment as to why those agencies are saying that to you.
Mm-hmm.
All right. So I'm going to move to our next question. Was that a hand? Go ahead.
I think that for some folks, talking to an attorney and getting more information might be cost prohibitive. Could you give us a rough estimate on what costs would be? I know it totally depends on each situation, but maybe a range of typical situations to engage with you.
I would say call our office. It's not a status. So the question is, can we give a range of fees for planning? And my answer for myself will be not satisfactory to you right here, right now at all, which is please call my office. It really depends. My office has a certain fee structure. If you call another office, it's a totally different fee structure maybe. So I would say call, ask the questions, share your story, and ask for an estimate when you call your chosen attorney. That would be my...
Right, and I would say it's not a one size fits all. Everybody's situation is different. And at my office, it's the same thing. We have a fee structure. I would say consultations are billed hourly, and then that's when I get most of my information to know, okay, what my next steps are in order to either quote a retainer for an hourly matter or quote a retainer for a flat fee matter. So it's usually that consultation that I usually get the building blocks of what I'm really helping this person with in order to essentially say what the fees would be or the cost structure would be. So my hourly rate is $325.
And I don't think either that, I mean, when you call, you're going to give a certain amount of information, and that's going to guide the conversation a whole lot. But we often compare estate and special needs planning to an insurance policy. If you drive a car, you have insurance, and you are paying insurance on that vehicle every year. This is a one-time big payment of insurance. And unlike car insurance, where you hope you never need it, and if you don't have an accident, you won't, we're all going to die. That's going to happen. So This is an insurance policy you're putting in place for the family members that you're leaving behind. That's crass, and you know, I can make light of it because I'm alive, and so are all of us. But we are all going to die, and so this is not an insurance policy that we may not ever use. It will get used. The plan that you put in place is the plan you're putting in place for the people you're leaving behind, which may be your disabled adult child.
Thank you for not sugarcoating.
I like that analogy too.
A related question. When you were talking earlier about guardianship in the state of Vermont, where the individual can choose or doesn't have to hire an attorney, and the disabled individual also gets an attorney, is that a court-appointed attorney?
Almost always, yeah. If you have your own attorney, if the disabled adult individual, or if the individual who guardianship is being sought for has their own attorney and they want to use their own attorney, by all means they can. But there is no petition in Vermont for legal guardianship over someone where that someone is not represented by an attorney. And I said earlier too that the attorney's job in that respect is to advocate for the individual's expressed interests, whether or not those are their best interests. If they cannot communicate about their interests for whatever reason, there's what's called a guardian ad litem, which is appointed to be the liaison, essentially, the middle person between the individual and the attorney. And that person does advocate for best interest. So unlike the attorney whose job is to advocate for the expressed interests, the guardian ad litem can make an assessment. They meet with everybody involved and they can make an independent assessment.
I would say in New Hampshire, it's a little bit different. So if that individual can express whether or not they're taking a position on the guardianship to their court-appointed attorney, there's no guardian ad litem that steps in. The court-appointed attorney at the hearing would just say that the individual was unable to communicate effectively and is not taking a position on, the court-appointed attorney is not taking a position on whether or not the guardianship is necessary at the hearing.
Would there ever be a reason to change voluntary to involuntary guardianship?
Would there ever be a reason to change voluntary guardianship to involuntary guardianship? Once the voluntary guardianship has been established, absolutely reduced capacity of the individual. If their ability to manage their affairs lessens over time, you may need to go back to the court and have the guardianship changed to an involuntary guardianship. I mentioned that a power of attorney and advance directive for healthcare are documents that we can all prepare and we can all revoke at any time. The voluntary guardianship, the individual themselves can petition the court to terminate that guardianship at any time, but it's ultimately up to the judge. And likewise, if you're transitioning to an involuntary guardianship, all you're really doing in that case is putting a tighter lock or an extra lock on that guardianship that's in place, because it's the same power, it's the same gold seal, but the individual no longer has the right to petition to revoke that guardianship.
My daughter gets a letter every year from the probate court saying, if you don't want this, you can change it.
So your child has a voluntary guardianship and you are your child's guardian, and every year your child gets a letter saying you can revoke this guardianship if you want. Yeah.
Well, she's dropped up and she's going to find it. But that would be the only reason.
Yeah. It's really hard. I don't know from personal experience, though. I'll share that. But just working with parents, this is another situation where you're going to court and you're highlighting all of the worst characteristics of your precious child or family member. And you are proving to the court and perhaps arguing with your family member about how incapacitated this person is and how incapable they are of managing their own affairs. If it's appropriate, just keep the end goal in mind as you're pushing through, because that is extremely challenging for everyone. the individual, him or herself included, but it can be essential for supporting them in the future. Maybe, again, that's up to the judge to decide if that really is most appropriate.
So I would say in New Hampshire as well, even if we don't really have voluntary or involuntary guardianship, but if the annual report comes up, that individual, the ward, does still get a letter that if they're still in agreement with the guardianship, because it can be terminated by that person. But again, if that individual does want to terminate, it's usually the petitioner or the guardian that's putting up a hearing, making a petition to the court for a hearing that it shouldn't be terminated and the reasons for why it shouldn't be terminated.
My daughter wouldn't know where to go to even, but. And
that's an example of why it shouldn't be terminated, right?
All right, we have about 20 minutes left. I have a couple more questions. I've only asked 4. But this next one, I think, is, you've been answering some of this right along. Mm-hmm. So from your legal and financial perspectives, what are the most common mistakes families make in this area, and how would you suggest they avoid them?
So I can start from the financial perspective. So we see a lot of families, and we're putting together their financial plans, and all of their benefit stuff is kind of happening in the background, and they think things are set and they're good for the period of time that you're in, and then the child inherits money that completely disqualifies them, and we didn't talk about that. Or you haven't thought about who's going to take this guardianship over when you pass away. I think it's so hard to think about all the really blunt what happens when I die. This isn't just an in-the-moment thing for your kids. It's for the rest of their life, which will likely be longer than your lives. And thinking past what they're going to do without you is so hard, but it's so important when you're thinking about these plans. And we'll get into that a lot more with special needs trusts and stuff at the next session. But thinking really, really long-term. And it's really tough.
I would say I have family members I'm doing, and again, this touches on next topic too, meeting with a family for estate planning, and they have a child with special needs, and they completely want to write them out of their plan because they just don't want to leave them with any inheritance, because any inheritance that they leave to that child is going to knock them off of their benefits. And it's kind of like a educational segment for my clients, because I tell them that they can leave funds to a child with special needs through their estate plan, and I walk them through the ways that they can. So it's usually trying to educate clients that they don't have to write a child with special needs out of their plan. They don't have, they can certainly leave an inheritance to that child. It's just the planning aspect of it. How do we plan for that, and where does it go?
I can attest to the fact that if you ask the wrong attorney who is not familiar with that type of planning for people with special needs, it's not.
Right.
For example, when my brother did come up, he had retirement funds in an account, which had been kept in a special trust of some sort in New Hampshire, and they said, oh, you can do that if you want to. And I asked the wrong person.
Yeah.
And then I talked to the state, and they said, oh, he has to spend that down.
Mm-hmm.
And they suggested exactly what he could spend it. And I just wanted him to be in a position where he was okay to get his benefits that he was supposed to.
Right.
And so he did spend it down on things that he needed, basically, but still.
The comment is that you need to talk to an attorney or a financial planner, but who has knowledge in this area, and that's absolutely a valid point. And it's not inappropriate to ask when you're seeking an attorney for special needs planning, when you're seeking a financial advisor and you have a special needs family member, when you're seeking a trustee for your special needs trust, ask what experience those people have with folks like your family member. It's not inappropriate to ask what experience they have. And you want to work with someone with appropriate experience.
And from a perspective of an organization that is not a financial planning or legal organization, we can if you say we want to have someone who is knowledgeable in this area in Vermont or New Hampshire, you can reach out to us and we can kind of give you a list. I will tell you that we reached out to people who we knew of also who focused in these areas, and there's a couple other individuals who you'll see next time and the time after that as well. But we could give you something kind of independent if that's helpful to you. Yes.
Stable accounts in Vermont anyway, where you could put savings into the fund for the child or guardian, and that is exempt from income.
So the comment, or is that a question? Comment is that in Vermont and in New Hampshire, ABLE accounts exist, referred to as stable when you blend state ABLE together, and it's accounts named after Achieving a Better Life Experience Act. They came to Vermont in 2017, maybe earlier or later in New Hampshire, but it's a savings tool for individuals who are legally disabled, and the standard is actually lower for proving disability for an ABLE account than it is for obtaining SSI and Medicaid. But it's a savings tool. You can contribute up to a certain limit per year into an ABLE account, and the funds in the ABLE account will not count against the individual as a resource.
Until they get to 100,000.
Until the balance reaches 100,000, and then for SSI is suspended, not eliminated, but it's suspended until your balance is back below 100,000.
Do you know, and this might be really specialized, do you know if you can convert a 429 to an ABLE?
So the ABLE accounts were kind of arbitrarily developed under the same statute as 529 college savings accounts. So 529 college savings accounts are accounts where the money is for educational expenses only. ABLE accounts is 529A. And it's for qualified disability expenses only. And yes, there are ways to convert if you have a 529 college savings account established for an individual who turns out is never going to use it for college but could use it in an ABLE account. There are ways to convert.
Cool.
I think one of the things that I'm taking away from this, and this is a comment, is that this planning is so important. I think for us, what's really prompted it is that we have an 8-year-old biological child now and 2 adopted 19-year-olds, and we don't want this to fall on her. And I feel like it's going to, if we don't figure this out now. She's going to take care of her brothers.
The comment is just reiterating the importance of doing special needs planning for everyone involved, especially siblings who are likely to survive alongside their disabled adult sibling.
As you might have noticed, today has been more about what you can do now while you're alive, right? It's about guardianship, it's alternatives, entitlement programs. These are all things for now. Next time is a little bit more about how should you plan for when you are not here. Whether you're a guardian or you have children who are going to always receive some of these entitlement programs because of disability. So that's how it's set up for next time. And we'll ask the last question here today, and it goes back to that question of independence and support. So how can parents and guardians best advocate for their child at whatever age while balancing both their independence and support?
I'll just quickly reiterate what I've said before, which is advocate for the most, and you can always work your way down. That starts in school. So any school supports that your child is eligible for, push for the maximum. You can always back off if it's appropriate, but don't let the school push you off. I'm making this, it's a general statement, so again, generally speaking. But if the school says your child doesn't need these 3 supports anymore because look how great they're doing, you've got to push back and say they're doing so great because they have these other supports. Push for the maximum amount of supports. That's how you're going to push towards that independence, push towards the greatest success, whatever that looks like for the child. And that goes for benefits moving forward in the future. Again, charging your adult child rent to live in your house just because they turned 18, might make you a little sick to your stomach, but you are ensuring they're receiving the maximum SSI benefit. Fighting in a guardianship court for guardianship will allow you to be making smart, educated healthcare decisions for them when they are not able to make healthcare decisions for themselves, even if you had a battle getting that guardianship. So generally speaking, my advice would always be push for the maximum, because it might feel like you're taking independence away, but you're ultimately usually enabling greater independence for that person.
A lot of times too, you can give them autonomy by discussing and letting them get involved.
Right, even with a guardianship. Yeah, I second that. I would say, I'll give an example. I had a client who their child was turning 18, and, you know, they still were able to get a guardianship over their child, but the child made leaps and bounds while still being under a guardianship. So much to the point that 8 years later, that child wanted to get their driver's license. But on the petition for guardianship, we had ticked off the box where that individual couldn't drive or obtain a license. So we petitioned the court and we said, this person, we still want to have the guardianship, but we want to repeal, we want to take back the fact that he's not able to drive anymore or obtain a license. He's made leaps and bounds, and now he can go to driving school and he can obtain a license. And here's the evidence as to why he can. So I would say, following Kaitlyn, yep, if a guardian, if you're feeling that ick about getting a guardianship in the first instance, you can still receive it with those examples of incapacity. But you can work with your child in order for them to, if the child is capable, to move forward with certain things and start repealing some of the guardianship orders back, and maybe eventually, if they ever get to that point, completely terminating a guardianship. So I agree with Kaitlyn in the sense that ask for the max and then work with your child and see how far along they come if they're able to.
I think it's a mindset shift, and it's hard because you're told you want to send your child free into the world, but getting all these supports in place is their best chance at doing that. And shifting your mindset from taking away their independence to giving them the tools that they're going to need to be more independent it just is a little reworking.
All right, any last questions? Anyone online? I loved that we just ended with hope. I don't know if any of the rest of you just heard that, but the story in particular of the young person who got their driver's license, right? When you're making these decisions, you're not saying, oh, they'll never be able to do that. You're saying they can't right now, and we're going to work really hard to get there. And if they get there, then we can let them go more. So I really like that piece of hope that we ended on. Thank you, everyone, and we will see you next time.
Thank you.